Good? Keep your hands above your head.
Don't move.
What's going on? Why am I being... We'll explain everything in a second.
Can I get
Who
my
else is in
cell
the
phone,
truck?
please? No one else is in the truck, sir. Can I please get my cell phone?
We'll get it for you.
Don't worry
Stand
about
up.
yourself.
Please. Where are you taking me?
We're taking you to the car. Come on.
It was a regular Friday evening, shortly after 7:30 p.m. on September 16, 2022, when the life of 20-year-old TSA agent Yareni Rios Gonzalez took an unexpected turn. Just north of Platteville, Colorado, she found herself pulled over by an unidentified officer from the Platteville Police Department. Within minutes, two more officers, their identities concealed, rushed to the scene from the Fort Lupton Police Department. The reason for this unexpected encounter was a call reporting a potential road rage incident involving a firearm. As Miss Rios Gonzalez brought her vehicle to a halt just past a set of railroad tracks, the Platteville officer parked his vehicle behind hers, positioning it on the tracks. This marked the beginning of an incident that could have easily turned tragic. All three officers swiftly exited their vehicles, their authoritative presence escalating the tension in the air. Shouting orders at Miss Rios Gonzalez, the situation unfolded rapidly, with the potential for dire consequences.
Driver, let me see your hand. Put both hands out the window. Both hands out.
Dispatch Lupton 346. We're giving commands. Her hands are out the window at this time.
Open your door. With your right hand, open your door. Come on out.
Yeah. Dispatch Lupton 346. She's out of the vehicle. Hands are visible.
Want to go to this side?
Yeah. Vasquez! Hey!
Lift your hands up. Lift your hands up. Okay? Turn around. Turn around. Turn around. Put your hands up higher. I want you to set your phone down at the edge of your truck.
On your left.
You don't need it. You can leave it on. Come on back. Keep coming back. Keep your hands up. Keep coming back. Keep coming back to the sound of my voice. Keep coming back. Keep coming back. Keep coming back. Keep coming back. Stop right there. Get down on one knee and then the other.
I got cuffs.
Go ahead.
Good? Keep your hands above your head.
Don't move.
What's going on? Why am I being...
We'll explain everything in a second.
Can I get
Who
my
else is in
cell
the
phone,
truck?
please? No one else is in the truck, sir. Can I please get my cell phone?
We'll get it for you.
Don't worry
Stand
about
up.
yourself.
Please. Where are you taking me?
We're taking you to the car. Come on.
Why? What?
Do you have anything on you that's going to poke me, stick me, hurt me?
No, ma'am, but can I please get my cell phone?
We'll get your cell phone in a second. Is there any weapons in the car?
Ready?
No, ma'am, there's nothing on
There's
there.
no weapons in the car? Okay.
Everybody out in the car, come on.
What's going on? Ma'am, what's going on?
I'll tell you in a second. Take a seat.
I'm so confused. Can I get
Take a
my
seat.
cell
I will get your cell phone for you. Take a seat.
A female officer swiftly intervened, handcuffing Miss Rios Gonzalez and guiding her into the backseat of a police cruiser. Oddly, this cruiser had chosen an unconventional spot, resting on the train tracks, a detail that draws attention to Section 42-4-11204 of the Colorado Ribeye Statutes. This section, somewhat like a traffic conduct rulebook, explicitly states that no person should park a vehicle on railroad tracks unless absolutely necessary to dodge traffic conflicts or following the directives of law enforcement or traffic control devices. It's a simple guideline aimed at keeping everyone safe on the roads. Violating this rule could result in a Class B traffic infraction, a legal hiccup that one would want to avoid. For a more nuanced perspective, Section 42-4-108 of the Colorado Revised Statutes sheds light on the privileges granted to drivers of authorized emergency vehicles. This provision acknowledges their unique role during emergencies or chases, yet it wisely emphasizes that these privileges don't excuse them from the duty to drive responsibly, considering the safety of everyone on the road. In essence, the law recognizes the urgency that emergency responders sometimes face, but firmly reminds them that safety is non-negotiable. It's a subtle balance, reminding those in authority that their actions shouldn't jeopardize the well-being of the community they serve. Now, let's zoom in on the peculiar situation unfolding on the train tracks. Picture this: an unattended police cruiser, Miss Rios Gonzalez in handcuffs in the back seat, stationed on the railroad tracks. It's not just a violation of the rules, it's a stark display of reckless disregard for the safety of not only Miss Rios, but also for anyone on an approaching train. The potential consequences are significant, not only for the person in handcuffs, but also for the law enforcement personnel and unsuspecting train passengers. In the eyes of the law, this isn't a mere oversight. It's a clear-cut case of negligence. Courts, with their measured approach, are likely to frown upon such blatant disregard for the safety of others. Beyond the legal implications, this situation paints a larger picture of the delicate dance between authority and responsibility. As the minutes tick by, one can't help but wonder about the potential fallout. The legal intricacies aside, this incident serves as a stark reminder that even those tasked with upholding the law must do so with an unwavering commitment to community safety.
I see a car seat. Clear. Okay, let's get the bed. Come across. Clear. Dispatch Lupton 348. Vehicle's clear. You can raise the channel.
It took her a long time to pull over.
I got a holster right here in the passenger seat.
It took her a very long time to pull over. I'm going.
Did you see her toss anything?
I sure could have, because it took her a long time to pull over.
As Miss Rios Gonzalez found herself confined in the back of the unattended police cruiser, an unsettling sequence of events unfolded. Instead of ensuring her safety in this vulnerable situation, the officers proceeded to search her vehicle for a firearm. This raises eyebrows, especially considering her precarious position on the train tracks. In the legal realm, the 10th Circuit Court of Appeals, the authority covering Colorado, offered insights in the 2003 case of Raska x Relaska versus Peterson. The court emphasized that government officials must ensure reasonable care and safety for individuals under their custody. Quoting the Due Process Clause of the 14th Amendment, it asserted that life, liberty, or property cannot be deprived without due process of law. However, the legal landscape becomes more nuanced, as highlighted by the 1977 case of Ingram versus Wright. The Supreme Court emphasized that the right to be free from unjustified intrusions on personal security is part of the liberty preserved by due process. Yet, the 1989 case of Deschenais versus Winnebago County Department of Social Services added a layer, asserting that, in general, due process doesn't create a state duty to protect against harm caused by a third party. But, and it's a significant but, when the state takes an individual into custody against their will, the Due Process Clause imposes a corresponding duty to assume responsibility for their safety and well-being. This duty arises from the state's affirmative act of restraining the individual's freedom, be it through incarceration or similar forms of restraint. Nevertheless, the Supreme Court clarified in the 1986 case of Daniels versus Williams that a negligent act causing unintended loss or injury doesn't trigger the Due Process Clause. Mere lack of due care by a state official, the court asserted, cannot deprive an individual of life, liberty, or property under the 14th Amendment. So, how does this translate to Miss Rios Gonzalez's situation? The 10th Circuit Court of Appeals, in the 1990 case of Barry versus City of Muskogee, set a standard: deliberate indifference. This standard goes beyond ordinary lack of care and requires more than negligence, or even gross negligence. While it falls below intentional and malicious infliction of injury, it demands a higher degree of fault. Deliberate indifference, as the court explains, is a legal standard used in the context of constitutional law, particularly in cases involving claims of violations of an individual's rights under the Due Process Clause of the 14th Amendment. This standard is often applied to cases where government officials, such as law enforcement officers or corrections personnel, are accused of failing to protect someone in their custody from harm, as with Miss Rios. Deliberate indifference goes beyond ordinary negligence or lack of due care. It requires a higher degree of fault. To establish deliberate indifference, a plaintiff must typically show that the government official demonstrated a conscious disregard for a known or obvious risk that was likely to result in the violation of the individual's constitutional rights. In practical terms, it means that the official knew of a serious risk to the person's safety and, despite that knowledge, took no meaningful steps to address or mitigate that risk. This standard acknowledges that, in certain situations, officials have a duty to protect individuals in their custody, and a failure to fulfill that duty in the face of a known danger can be legally actionable. In Miss Rios Gonzalez's case, leaving her in the back of a police cruiser parked on train tracks could be seen as meeting this deliberate indifference standard. The officers, by disregarding the obvious danger posed by parking on railroad tracks, demonstrated a total disregard for her safety. However, as we delve into the legal intricacies, it's essential to acknowledge that a court might consider a different legal standard for this specific situation.
As we will discuss momentarily, it is also possible that a court could conclude that a different legal standard should be applied to this situation.
She could have, because when I was behind her, she was driving slow enough.
Yeah.
So she could have tossed something, but I literally
Tossed it out the window?
She could have out that window, but who is that car?
No, that's
Maybe a car.
time check. Oh my god. Did us medical emergent. The suspect was in the vehicle that was hit by the train.
Watch the fence.
While the officers persisted in searching the vehicle, an unfortunate twist of events unfolded. A train, oblivious to the unattended cruiser still parked on the tracks with Miss Rios Gonzalez inside, approached and collided. As we explored earlier in this narrative, the Due Process Clause of the Constitution prohibits officers from displaying deliberate indifference to the well-being of individuals in their custody. However, navigating the legal terrain becomes more complex. In the 2014 case of Walton versus Gomez, the 10th Circuit clarified that while the 14th Amendment governs claims of excessive force for detainees with a prior judicial determination of probable cause, the 4th Amendment takes precedence for those detained without a warrant and before any probable cause hearing. According to the 10th Circuit, as outlined in the 2019 case of McCown versus Morales, a 4th Amendment excessive force claim is evaluated based on a purely objective standard. An officer violates an arrestee's 4th Amendment right if their actions were not objectively reasonable given the facts and circumstances at hand. This standard, although more lenient than the deliberate indifference standard applied in due process cases, raises uncertainty about which standard a court would apply in reviewing the situation. While the 10th Circuit seemingly clarified in the Walton case that the 4th Amendment applies to an arrestee without a probable cause hearing, legal waters get muddied. In the 1997 case of Berry versus Grand County, Utah, the 10th Circuit applied the deliberate indifference standard to a case involving the suicide of an individual arrested without a warrant and held in jail before a probable cause determination. The court argued that the reasonableness standard only applied to claims of excessive force, asserting that jail suicide claims, viewed as failures to provide medical care, required the deliberate indifference standard. A noteworthy point, though, is that in a concurring opinion, Circuit Judge Briscoe contended that the 4th Amendment doesn't only prohibit excessive force, but any unreasonable seizure. Given the unprecedented nature of the circumstances in this episode, it remains plausible that a court could adopt Judge Briscoe's reasoning. The court might conclude that the circumstances surrounding Miss Rios Gonzalez's arrest were unreasonable, violating the 4th Amendment. Alternatively, a court might lean towards applying the 14th Amendment's deliberate indifference standard, considering Miss Rios Gonzalez wasn't subjected to direct force from the officers. Regardless, Miss Rios Gonzalez has a compelling argument that the officers, in some capacity, violated her constitutional rights by exposing her to unnecessary and life-threatening danger after the accident, placing her directly in harm's way.
There may still be a firearm in the vehicle. I don't know if you guys have been through it yet. We weren't sure if she threw it or if it's still hidden in the vehicle somewhere. It took her a long time to pull over.
Right now I just need to find out who she is. You hear that?
No, I didn't hear that.
There's a round over there in the door.
Miss Rios Gonzalez faced a harrowing journey of recovery. She was swiftly transported to a Greeley hospital, where a comprehensive evaluation revealed the extent of her injuries: 9 broken ribs, a broken arm requiring surgery, a broken leg, a fractured sternum, and injuries to her back and head. Her resilience shone through as she spent over a week in the hospital, facing a prolonged recovery period ahead. According to her attorney, Paul Wilkinson, Miss Rios Gonzalez vividly recalled the details of the crash. She recounted desperately trying to grab the attention of the police officers, screaming at them while attempting to unlock the door with her hands behind her back. These haunting details paint a vivid picture of the terror she experienced in those critical moments. In the aftermath of this traumatic incident, Miss Rios Gonzalez has chosen to take legal action against the police departments involved. Her decision reflects a pursuit of justice and accountability. Multiple agencies are now diligently investigating various facets of the incident, underscoring the severity of the situation. The Fort Lupton Police Department spearheads the initial criminal investigation, while the Colorado State Patrol delves into the serious injury traffic accident between the train and the cruiser. Simultaneously, the Colorado Bureau of Investigation is reviewing the serious bodily injury that Miss Rios Gonzalez suffered while in police custody. The gravity of these investigations underscores the potential legal ramifications for the officers involved. Platteville Police Chief Carl Dwyer has confirmed that the Platteville police officer implicated is on paid administrative leave during the investigation, though the officer's name remains undisclosed. The Fort Lupton Police Department has opted not to comment on the unfolding unfolding situation, leaving the community awaiting further developments. In evaluating the officers' actions, it becomes evident that both the Platteville and Fort Lupton officers exhibited a shocking lack of common sense and an alarming level of incompetence. Their actions, from parking on railroad tracks to leaving a handcuffed suspect unattended in the vehicle, demonstrated a blatant disregard for Miss Rios Gonzalez's personal safety. The focus on searching for a firearm rather than ensuring her well-being adds another layer to their questionable priorities. It is indeed remarkable that Miss Rios Gonzalez survived such a perilous encounter. In the face of this recklessness, one can only hope that the police agencies involved will hold these officers accountable for their actions. The need for responsibility and corrective measures is pressing, emphasizing the importance of maintaining public trust and safety. As for Miss Rios Gonzalez, she stands as an unfortunate victim of police ineptitude. Her perseverance and decision to seek legal recourse speak volumes. In a situation where she had no control over the harm inflicted upon her, her courage in pursuing justice is commendable. In a shocking turn of events, the Colorado police officer, identified as Jordan Steinke, has been found guilty of 2 misdemeanors. Miss Rios Gonzalez herself continues to grapple with the haunting memories of being handcuffed in a patrol car with nowhere to escape as a freight train approached.